All right, and we are here for what was marked as a prelim, but I think we have finally obtained everybody's magic signatures to transfer this case down to St. Joe. Am I correct on that?
I believe so. I've been working on this quite a bit. Yes, I believe it. And everybody has signed the memorandum of authority.
Okay, then all that's left to do is send the files down to St. Joseph County and let them take it from there.
Well, I believe based on how under paragraphs 2 and 3, St. Joe wants Wexford to abstract, and then they want you to, they want you to abstract.
They want us to take the plea, don't they?
Take the plea, and then do the abstract, and then any initial jail would be up here, but we sobriety court would be arguing that no upfront jail would be appropriate, and then Mr. Rose can pay his fines and costs today if needed.
We're the transferring court, they're the receiving court, right?
Correct.
So they're responsible for abstracting. No, okay, never mind. It circled one spot and typed in another.
I know, I had filled this form out and sent it up on the 19th, waiting to hear any feedback on it. Last week, Thursday, I had gotten an email that said that, that was what you wanted, and then I hadn't had Mr. Rose sign it initially until last week, Friday, because I was waiting for feedback. And then when I realized Thursday and Friday that it wasn't getting passed around, then I started, I guess, working harder on that because I knew we had today, yesterday being a holiday.
Let me take a look at something. Yeah, so now we're kind of at an impasse because after everybody signed it, it appears that the receiving court modified the order. So that makes my signature void and that makes my chief judge's signature void. So I can't move forward without my chief judge's signature. But what I'm willing to do is resubmit this to her. We can set this for next week. Yeah, we'll set it for next week and I'll allow you guys to appear by Zoom so you don't have to come back up here for this.
Okay.
And actually, I think it's going to take everybody's re-acknowledgement of this, because if I recall correctly, and based on what I have in front of me, let me just double check. The defendant signed it before, the defense attorney signed it before, Ms. Carey signed it before. My chief judge and my, yes, if you guys want to initial this, you're more than welcome to come up and initial.
I'll just put my initial next to my name and date it the 2nd. Yes, I'll bring it to you.
I'm somewhat perplexed because I remember stating that I would not take a plea and transfer out. That if I was going to take a plea, I was going to sentence. And so now we're kind of changing the, all because the receiving court wants to change things. It's my
It would be
decision.
helpful if Rose Navarro would be in contact.
Well, we can't just blame it all on her. And I know we like to do that, but here's the thing. I was very clear that I would not do a transfer unless the entire case was transferred to the other court before taking the plea. That I would not take a plea and transfer. I remember having that conversation in chambers. And we.
Can St. Joe take a plea to a Wexford case?
That I don't know, but I was clear as to the only term I would transfer it out. I'm assuming it would, because it's marked here that the transferring court / receiving court is responsible for providing the information to the state police, and that they're into the Secretary of State. But I'm not inclined to plea for me to accept a plea and then transfer one of my cases to another court for supervision in another area. That's just not something I'm gonna do.
What's the difference though? Because he'd be transferred to St. Joe County for probation anyway, most likely.
But it would be under my sentence, not another court sentence. And I would be the one making the decision as to whether or not he's been successful in sobriety court in the terms of probation, not another court.
You're saying that you if it goes that way. I'm saying if he pled straight to a misdemeanor and did regular probation, he would still most likely be transferred to Centerville anyway after.
His supervision would be transferred, but any violations would still be before this court.
Right, right. I guess the violations would be, as far as how I understand this, would be all in front of St. Joe, wouldn't they?
That's what I'm saying, is you're asking me to take a plea, to take the plea and then transfer the entire case out of my jurisdiction after I've already taken the plea. If I take the plea, it should be my prerogative to sentence the defendant as I see fit. And then if we transfer the entire case down to St. Joseph County, all I've done is take the plea. They're handling everything else down there. And I was clear that I was not doing that.
Even though the MCL 600.1088 states that, I mean, you can have a total transfer of case even after adjudication.
I know what the statute said, and I was clear that I wasn't doing that. And the order was written up the order that we all signed was written up that way.
But I wasn't,
I understand that. St. Joe County is the one that changed it, but St. Joe County essentially changed the entire format of what I said was I would do.
so is that, I mean, are we gonna send it up to the chief judges there and see where we go from there, or where does that put us at for today then?
Well, I guess where I'm at is I'm gonna have to have a conversation with the judges down in St. Joseph County and figure out what's going on. And then I guess we'll have to have everybody back next week and figure out what we're doing. I will tell you one thing that this has done. It has established that I will never transfer another case for sobriety court purposes. This thing has been just a never-ending nightmare. So we are once again adjourned. I will follow up with the judges down there to find out their procedure. And I will have to check with my chief judge. If she says no, then we're back to where we are.
Okay, what time is it? Can we appear by Zoom on this?
Yes, you can.
Okay.
It'll be next Tuesday at 2:00.
And your Zoom information is the same as it was way back at the arraignment, right?
There was a change in there. Was that after the,
Yes.
or before the arraignment?
Yeah.
Okay.
Will the new number be on the notice?
I'll read the number on it.
Okay, thank you.
New beginning half.
Okay, you can go back out where you checked in, and get your next court date. Thank you. Mr. Taylor?
Yes, court gave us the date of September 9th for our next hearing. I've been summoned for jury duty to come to county on that date. I haven't been called off yet at that point. I don't wanna.
All right, and it's that date you have jury duty?
Yes.
All right. Then what the court will do is I will move this to the 23rd of September. We have a visiting judge the 16th, and I don't want that visiting judge to have to deal with this, so we'll move it to the 23rd.
I had cleared the 16th. I didn't make for certain that the 23rd was a clear date. Checking with my office staff right now.
Sure.
That'd also be at 2 p.m.
Yes.
Would we be able to do it as like a status conference on another different day, like I have a jury trial in that case for the prosecutor on that day where the prosecutor has already asked for an adjournment. The court in Cass County denied it. On the 23rd of September.
Do I have time on the 19th of September?
Should in the morning.
Ms. Carey, are you available September 19th? So in the morning, you probably have circuit court.
Fridays.
Yes. What about the afternoon of the 22nd?
September 22nd.
Is that Monday?
Yes. So 2 out of 3 of us are available the 22nd. No, I get it.
We might not have circuit court on the 19th, according to the deputy schedule. But Monday is fine.
Zoom on that one.
You
Okay,
can, yeah.
right. Yes, I can do the 23rd, or, I'm sorry,
22nd.
22nd. And
What time, Madam Clerk?
Let's see. We can do it right after arraignments at 2:30 to be
2:30,
safe.
you said?
Yeah.
So 9:22 at 2:30.
2:30. Can I make it for prelim or?
Yeah, just set it for status conference. Okay,
All
thank
right,
you.
let's talk about that. This hearing in front of Judge Corey J. Wiggins was less about the defendant and more about the courts themselves, trying to figure out who gets to handle what. On paper, it looked like a straightforward transfer for sobriety court purposes. In practice, it turned into a tug of war between two counties over who should take the plea, who should sentence, and who should supervise probation. Judge Wiggins's demeanor was steady and professional throughout, but you could hear the frustration in his voice as he untangled the paperwork trail. He was clear, calm, and patient with counsel, but he also drew a firm line. If he takes a plea, he's the one doing the sentencing. Period-dant Mr. Rose was mostly in the background here. He had already signed off on the paperwork, and his demeanor was quiet and cooperative. He wasn't argumentative or evasive, just watching as the courts debated over procedure. His attorney, Mr. Taylor, and the prosecutor, Ms. Carey, were both professional, though clearly exasperated with the back and forth between counties. Taylor even had to juggle his own calendar with jury duty, which added another wrinkle to an already messy scheduling puzzle. What made unique was the glimpse into how intercounty transfers can bog down a case. Judge Wiggins pointed out that the receiving court, St. Joseph County, had modified the order after everyone had already signed it, effectively voiding the signatures and requiring the process to start all over again. He didn't mince words about his position. He wasn't going to accept a plea only to hand over sentencing to another court. His tone was matter of fact, not heated, but the message was unmistakable. At one point, he even said this ordeal had convinced him never to transfer another case for sobriety court again, calling the process a never-ending nightmare. It wasn't dramatic. It was the kind of weary honesty you only get from a judge dealing with red tape too many times. The overall atmosphere but slightly tense, not because of any outbursts, but because of the procedural impasse. The attorneys were respectful and engaged, offering to initial changes and adjust schedules, but the bottom line was clear. This case wasn't moving until the judges from both counties talked it out. Wiggins took control of the situation by resetting the matter, first for the 23rd, then moving it to the 22nd of September to accommodate Taylor's jury duty. He also allowed appearances by Zoom to cut down on travel, showing flexibility even while standing firm on principle. In the end, the defendant walked another adjourned date and the knowledge that his case is stuck in the gears of intercourt bureaucracy. Judge Wiggins showed fairness and patience, but also underscored that he won't bend on jurisdictional control. The attorneys kept their cool, the defendant stayed respectful, and the whole hearing served as a reminder that sometimes the courtroom drama isn't about testimony or arguments. It's about the system itself, trying to figure out how to function smoothly. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.